Speech by Dr. Habib Al Mulla.
Thank you. I'm so glad to be with you this morning. I think this is one of the most interesting subjects that everyone is interested in. And surprisingly, when I was coming here, I was watching a video about the launch of the version 4.0 of ChatGPT and the abilities that this new version has and the access to the information that it's having is quite mind-boggling, in fact. And till now, this chat has not had any access to legal data, medical data. Just imagine how things will change once, it's not if, it's once it gets access to this kind of data. So my talk today is about what regulatory challenges and the solutions and recommendations for policymakers. Now, given that the tech landscape is ever changing, it's critical that policymakers adopt strategies to keep up to date with the technological advancement and address the concerns of the market-driven industry. In my view, the technological policies require similar models adopted by governments to address similar to public health and public interest issues. The first recommendation, in my opinion, is to clarify the legal framework for digital assets. In civil law countries, complex and novel issues of digital assets cannot be developed through common law and equity. UAE is, of course, a civil law country. So it's more crucial to set out the statutory framework for clarity and certainty in civil law countries. The same is equally true for greater predictability, even in common law countries. A, cryptocurrencies, in my opinion, should be classified as property. Why? This is so in order for claimants to be able to bring a property claim, the failure of which would seriously impair seeking injunctions and remedies for parties dealing with digital assets. B, digital assets should be classified as personal property. This will help in asset tracing. Such a need occur if, for example, dispute arose with regard to the digital assets. Data protection law should be amended in hand with the technological advancement to curb the threats that unknown algorithms of AI that can use personal data pose to the right of individuals, including the right to privacy. There is a greater need for more clarity and strong data protection safeguards as more and more industries and technologies rely on data. D, clarity on whether cryptocurrencies should be treated as securities or commodities for regulatory purposes to ensure compliance with the law. 2, we need a legislation for the valuation of digital assets. For example, if you have an issue of security for cost, policymakers need to decide if bitcoins, for example, and other cryptocurrencies can be used to furnish security for costs when disputes arise by courts or arbitral tribunals. B, policymakers need to decide should the court, for example, or a tribunal grant a specific performance or other remedy for digital assets, if it can be happen? I mean, specific performance can be ordered, or it's only damages that can be issued. C, if damages are given in lieu of cryptocurrencies and not in form of monetary damages, how would cryptocurrencies or other digital assets be valued? D, reforms to suggest how different type of cryptocurrencies with separate vulnerability, liquidity, storage, delivery cost can all be reconciled in view of the commercial expectations of the parties. 3, antitrust laws need to be drafted broadly and innovatively to ensure that they keep up with the technical innovations and often changing marketplaces. AI, and that's an important area. AI can augment human decision-making, a shift from the human race, from a subjective human process to completely objective and saleable process. However, there are severe risks of data theft, identity theft, misrepresentation, breach of security that arise with domestic legislation needs to tackle through regular amendment of the law and policy development. 6, critical related policies need to be developed as well. With boundless technological advancement, governments should ensure development of policies in other related sectors such as regulation of social media and right of expression with laws of privacy of individuals, state security, and national interest, policy governing bioengineering such as genome editing and synthetic biology, and threats to the health industry and the concern of food and water security and energy sectors. Now, we need to take also from the business perspective responding to risks and mitigating risks. Businesses need to be cautious and eliminate risk that technological advancement might pose. So, what solutions are there? While it's difficult for businesses to completely eliminate risk, they can adapt a TPM method, thinking in advance, early planning, and managing risks early and proactively. To engage in digital risk assessment and management rather than administrative models for better insurance and risk management. Increase technological expertise of institutions and management. Cost management. Increase the insurance premium for tech products need to be addressed through effective strategy alongside mitigating risk management related costs. And lastly, tech companies should engage in what we call ESG, environmental, social, and governance initiatives to create trusts and mitigate risks among stakeholders. Now, what are the trends in technological disputes and using technology for effective dispute resolution? With the tech boom, I expect that other than data privacy and security disputes, there would be disputes arising in IP, taxation, competition, finance, and insurance industry, and wide range of general, commercial, and corporate disputes, class action suits, disputes on product liability, supply chain issues, and regulatory and internal investigation to crop as well. Other likely disputes, I would say, cryptocurrency fraud cases, unknown digital identities. Now, traditionally, defendants were known. However, physical identity of holders of digital assets might not be known, and hence direct service, for example, on defendants might be impossible. And lastly, third-party crypto exchange holders. As disputes become more complex, third parties might be compelled for providing relief. Third parties to a claim, such as an exchange, which at the time of the claim holds misappropriated or stolen funds, can be joined as party to provide relief sought. Arbitration likely to be adopted to technological disputes. For example, we have CAS, Courts of Arbitration for Sports. We need dedicated courts for technology that resolves disputes through arbitration as long as things go forward. Unlike litigation, arbitration would help protect trade secret and other flexibility to parties. Blockchain arbitration system can be also used. Enforcement of awards. Now, if arbitration is not possible because there is no arbitration agreement, there is a solution. Singapore has adopted a Convention on Mediation, SCM, which provides assurance for effective resolution of disputes through mediation to users, as more states are ratifying the Convention on Mediation. Now, potentiality of technology to improve dispute resolution process. AI can be used for efficacious dispute resolution as it streamlines the existing process, making management of disputes, procedural strategy, and assisting with timely interim remedies like asset recovery. Arbitration appointment. We don't need to go anymore through human process to appoint an arbitrator. AI can effectively assess independence and impartiality of arbitrators. Experts in arbitration and litigation can be easily identified using AI, including their independence and impartiality. Document production. AI can be used efficiently to ensure time and cost-effective disclosures. Hearing and transcripts. AI can be used to implement real-time automated transcript written without any human interference. Legal research. AI can help in finding helpful sources, accurately translate legal sources from one language to another. And of course, the famous ChatGPT, although it might not be used to write submissions for courts or tribunal or expert reports, it can be used for acknowledgement of emails, sending cover emails, summarizing judgments, and summarizing expert reports and other documents related or required for litigation process. And I conclude by saying that while there are a number of concerns that need to be addressed at different levels, it is undeniable that the tech development is a boon for mankind. Whether or not the boon becomes a bane and cause tsunami wrecking mankind will depend on how fast the various stakeholders act. As a dispute lawyer, having worked with all the various stakeholders, including the tech industry, I think that the legal community will play a crucial role to mitigate the challenging and the risks that the tech industry forecasts. Thank you.